Good morning. Today I am going to discuss another case wherein an advocate played a vital role filing a complaint when somebody approaches him imputing allegations against the opposite party that he was uh, subjected to atrocities being a scheduled caste member. See, the way in which the council's prepared a private complaint applying its mind by reading the provisions of the Act, and the way in which the High Court has rejected quash proceedings, and subsequently when the Supreme Court held in a different way and quashed the proceedings. All these things are very vital to understand how the advocates are playing a different role in rendering justice. Here is the case. Actually, what had happened, B. Venkateswaran versus P. Bhaktavachalam. B. Venkateswaran versus P. Bhaktavachalam. This is AIR 2023 Supreme Court 262. AIR 2023 Supreme Court 262. B. Venkateswaran versus P. Bhaktavachalam. It's a case wherein senior counsel Nagamuthu appeared and successfully argued the case. The respondent seems to have appeared party in person, but the petitioner who approached the criminal appeal before the Supreme Court after filing SLP, the private respondent, there was a dispute between the private respondent and the appellant Bhaktavachalam, Venkateswaran. Actually, there was a pathway. According to the complainant, the pathway was encroached and a temple was constructed. Thereafter, there seems to have filed a civil writ petition to remove that, and subsequently writ petition was dismissed. Again, he seems to have filed another application wherein the division bench of Honorable High Court directed the authorities to take appropriate action against both the parties. But factually what happened, the temple was existing for so many years and the allegation of the complainant before the lower court was baseless. The private complainant, namely the Bhaktavachalam, seems to have filed a private complaint under section 200 before the Metropolitan Magistrate Egmore, filing complaint under section 200 CRPC, imputing offences, section 3, 1, 5 and 5A of the Scheduled Caste Scheduled Tribe, alleging that petitioner, original accused, was conspired and lawfully encroached the pathway adjacent to his house and started to construct temple. The temple was constructed over the water pipeline, sewage pipeline, EB cable, and caused obstruction to him to enjoy his property. Therefore, it was alleged that the accused did not stop illegal construction. Therefore, the 200 was taken on file. 202 process of application was issued. Therefore, thereafter, the accused filed 482 CRPC. The Honorable High Court of Judicature, Madras, dismissed the quash proceedings. But the Supreme Court categorically has held that prima facie none of the ingredients of section 315 and 5A of Scheduled Caste Scheduled Tribe are made out or satisfied. What section 5 and 5A says is most important. Wrongfully disposes a member of Scheduled Caste Scheduled Tribe from his land or premises, or interferes with his enjoyment of his rights over any land or premises or water. So, the complaint was very beautifully drafted. Unfortunately, facts are different. Drafting of counsel was best. Facts are different. Therefore, the complainant could not succeed and the Supreme Court has quashed the complaint. This is the way the advocates causes efforts to approach the court with their expert thinking because of by reading entire provisions of that. I hope you understand my uh, intention to present this case. You have to understand how the private complaints are even filed under SC/ST Atrocities Act. That the another things are different. I do not want to go on that because SC/ST Atrocities Act has to be tried by the special court. How this complaint was filed before magistrate, whether it is valid or not, that area of argument was not there. Only simply says that the complainant, by suppressing certain material objects, to take vengeance of a private dispute, filed this complaint. The allegation in the complaint are within the ingredients of the 315, but facts are different. Therefore, the Supreme Court has passed it. Best wishes.